Hello, good afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer your questions. Today I have a great topic. I am going to be talking about getting the marriage-based green card even in the case where you have a shady past. Some people have the misconception that once you have any type of issue in your past, whether if you've had a past arrest, no conviction, or a past arrest and a conviction, or if you've had past immigration violations, that it could render you inadmissible. But I'm here to tell you that that's not necessarily the case. While the immigration consequences, severe immigration consequences can range anywhere from being permanently barred to requiring a waiver, your situation may just be fixable, but you won't know that unless you actually schedule an appointment to discuss your particular issue. And that's why I'm here. I'm here to go through your particular situation in a consultation, determine you qualify for relief or you qualify for an immigration benefit, and then we get started right away as soon as we find the solution. So that's what I'm here to talk about. Though I'm going to talk about the what of those solutions, and then you can leave the how to me at this office. Now, let's talk about the shady past, right? When I refer to a shady past, I mean it could range from anywhere from you've overstayed, you're here without your status. While, sometimes that does happen for individuals, they feel like they are hiding in the shadows and that they have to hide their status or they can't apply for immigration benefits because of this. And that's not the case. And you also may have been arrested. It may be a traffic stop that may be resulted in a traffic violation that led you to be arrested or booked or to get a citation to appear in court. Now, when it comes on to things like traffic violations, they may not be serious enough to cause you to become inadmissible. When I say inadmissible, I mean when I say inadmissible, it means it doesn't make you ineligible for status in the United States. But even to the point that you have a record in your past, so for example, if you were convicted for assault, this type of criminal conduct could cause you to be inadmissible. Depending on the facts in your case, depending on the state you're in, it could render you inadmissible. And if that's the case, though, there's still ways to get forgiveness for this and then go on to get permanent resident. If you're here in the US and even if you're outside of the United States, these are through what's called waivers. So in this case, we would apply for a criminal waiver of inadmissibility. Now, there are two types of situations where you may be ineligible criminally. So first, if you have committed a crime involving moral turpitude, while this is a complex area of immigration law, and it really comes down to the facts to determine whether the crime involves moral turpitude, I can tell you that it's going to definitely be a depraved type of crime, a crime that not, the usual, a person in the usual standards of morality would not commit. So it is definitely takes a more detailed analysis to evaluate whether you would fall within that category. And it's kind of like a catch-all provision of the law. But then there's also the other one that if you've been convicted of two or more crimes that resulted in you being sentenced to 5 years or more, then that would also render you inadmissible in regards to criminal conduct. Other types of conduct that could cause issues for you would be if you came in with someone else's passport. It means that yes, you were inspected when you were coming in, but you misrepresented who you were and your immigration status, and because of that, you would have committed misrepresentation or fraud. That's likely. In this case, you would be inadmissible, and we would need to apply for for a waiver. But if you're here and you do qualify to stay here and apply, then this waiver could all be done here. Now, another is if you're here, say you don't have any of those issues, but you overstayed. Overstaying, there are ways to still apply for status here even after you've overstayed, and in some cases even if you've crossed the border without permission. So for example, VAWA applicants can apply for this relief. If you recall, if you join me on a daily basis, you'll know VAWA is where individuals can apply for permanent residence, for work permit, for the ability to stay here, and apply for their green card if they've been mistreated by a U.S. citizen or legal permanent resident, spouse, or parent, or a citizen's son or daughter 21 and up. So if that is the case, you would be able to apply for permanent residence while still being here, despite the overstay, despite coming across the border without permission. But it's going to really come down to your particular situation. So the point here that I'm trying to make is that if you do consider your past shady, just know that you shouldn't assume that you qualify or you don't qualify for an immigration benefit. You still can possibly obtain permanent residence in the United States. I would have to evaluate your facts, evaluate how you qualify for permanent residence. But even if you do truly have a situation that's going to render you inadmissible or ineligible, a waiver could fix that situation. So we can talk more about that. I do see, though, a question about controlled substances, and that definitely is a relevant question here because there is no waiver for drug trafficking. So if you're in possession of controlled substance, and in that case, you would be inadmissible. However, there are waivers available if the amount that you had was less than 30 grams and it was marijuana. If it is any other type of substance, there's no waiver for that. But if it's marijuana less than 30 grams, then you have a shot at getting a waiver. While it may not necessarily fall under a crime aggravated felony, there is standalone law that states that drug trafficking, possession of a controlled substance is not is going to cause you to be ineligible for a benefit unless you have less than 30 grams of marijuana and you have a simple charge of possession of marijuana less than 30 grams. So that is the one area where you may be able to get a waiver, but you would have to, of course, apply for that waiver. So if you have any kinds of issues in your past, don't assume I'm on your side. Schedule a consultation. The consultations are confidential. We will talk about your situation and determine whether a waiver would work for you. Let's see. So can EN3 green card holder change jobs after 5 months of getting the green card? No contract. So I wouldn't, Tanaji, I couldn't advise you on that, right? While it's always, you're not bound by the employer, what you have to understand is that there are other serious implications involved, right? You may not see the consequences of those right away, but if you leave shortly after you get your green card from your employer, then and you go on to try to apply for citizenship, it could raise a red flag to the officer that determines they would want a very, very good explanation as to why you left the job shortly after getting permanent residence, because that spells immigration fraud to them. And so I wouldn't be able to advise you though, because I don't know what your situation is. And so Tanaji, if you really want to get legal advice, I need to get details, understand your situation fully in order to advise you and to help you to prepare for the future going forward. Thanks for the love. I appreciate it. So keep putting those questions in the comments. So Nick, I was talking about individuals who have a past, and they may still qualify through a family member, through maybe even an employer, through humanitarian means for permanent residence, but they don't want to move forward because they're afraid that arrest or that overstay or that unlawful presence or will affect their ability to get the green card. And what I want you to take away from this is that it doesn't necessarily have to be some arrests, some criminal conduct. It does not even fall on the radar of the officers to render you inadmissible. You may be overreacting to the arrest or the conviction. But all of that comes down to an individual analysis on a case-by-case basis. That's why it's very, very important to schedule a consultation for us to discuss your matter, for me to understand it and advise you accurately on how you should move forward in your case, whether there's a waiver available, whether there's relief, whether it will even affect you. Remember, the information I'm giving you here is not personal legal advice, it's general information. And so that consultation, you can go to the link in the profile. Hi there on YouTube. I filed VAWA in November last year. I received my prima facie determination on March 31st. What's next? What should I expect? So it's going to depend, but with a prima facie, it usually lasts a year, and the next thing could be your work permit. But the work permit is not dependent on the prima facie. You could get that up to a year after applying, but that would be the next step. If you haven't already gotten your biometrics appointment, then you could also look out for that. All right. Okay. So I've been denied a US visa. The officer said I did not convince him I'm coming back home. How can I? So they usually require you to show strong ties to your home country. That's going to mean that you have to show you have a job. Maybe if you've been in the job for a long time, that you have future commitments, that you have strong ties, like your children, your spouse may be there, your rest of your family may be there. And so those could be evidence, and it all depends, again, on what else is going on in your situation. But those are the basic types of evidence that you can show. So I would love to learn more about getting a job. I'm from Tanzania. So Tanzania. It's going to depend on how do you qualify? What are your qualifications? Do you have family? Do you have an employer that qualifies you to be here? Thanks for the follow. I appreciate it. Do I need to keep any letter or record from current employer to avoid further consequences? It's always best to document everything and hold on to your documents. So there's no going wrong there. But Tanaji, once again, you should not be taking any actions based on what I say in this live until you get representation and advice. Is it bad after your interview if they request extra evidence instead of giving you an answer right there? So it is a sign that they need to review further, that they need to get more evidence to make a determination. But then again, it depends on what other types of evidence. Are they asking for your medical examination? Or are they asking for your, are they asking for more evidence of your bona fide marriage, if this is a bona fide marriage? So it's going to depend on what type of evidence. But if it's going to be anything to prove that the marriage is real, your marriage is bona fide, then you're going to have to make sure to work hard on that aspect of your case to prove, because it means they're not completely convinced. I'm trying to change jobs because of family situation. Okay. Don't have the shots. Can I start getting shots even before the medical examination? So yes, definitely you can. All right. So keep putting those questions in the comments and I will answer your questions. Now, in a minute, I am going to be heading on over to Instagram. When I am over there, you can join me there to continue asking your questions. This is going to be at 4:30 p.m. Eastern Time. Now, most of the content is released on Instagram, so videos, tips, announcements, updates. Join me over there where you can ask me anything that's immigration related. I don't limit you on questions, and I'll continue to have this conversation about applying for the marriage-based green card, even in the case that your immigrant spouse may have a concerning issue in their past. I just call it the shady past. If that's the case, just know that there are waivers available for certain types of conduct, but it really comes down to the facts involved in your case to determine whether you qualify and then to get started. Do you know how long it takes to get the waiver decision? So the waiver decision could range anywhere from 6 months to 2 years. Since the backlog, I've been seeing a lot more 2-year processing times than the 6 month. All right, so thanks so much for your questions. I will be back on Monday on here, so TikTok or YouTube at 4 p.m. Eastern Time in order to continue to take your questions and also to bring a great topic for you. So go ahead, mark your calendar, mark the time, 4 p.m. Around 4 p.m. you'll see me and we can continue this conversation. If you want to continue, you can also join me on Instagram or Facebook. Instagram, I'm the same username as here, which is The Immigration Attorney. Just type that in, look out for me, and then we can continue talking about immigration issues on Monday. Now, if you have a particular topic, like I know I saw a number of you, you had specific questions. If you do, go to the link in the profile. That's where you will see the contact information. Thanks, 876 Betty, for the reminder there. The contact information is going to be on the website. If you click on the link, it's going to take you there. You're going to see the phone number, you're going to see the online chat, and you're going to see the contact form. All three of those lead to the scheduling coordinators who will be more than happy to help you to schedule your appointment so we can get to the bottom of your issue and get going on your case. So thanks again for joining me. Thanks for your time, both on YouTube and on TikTok. I'll be back on Monday where we can continue this conversation. And that's if I don't see you on Instagram in a quick minute. All right. Have a good one, guys. Bye-bye.